Serial number 34, my lord. It's appearing for the complainant. My lords, may I request on 20th, my lords, the arguing counsel is not in station. The connected writ appeal, my lords, is also listed on 20th.
Serial number
34, my lords.
34, 20th,
20th, my lords.
22nd,
Please, my lords.
22nd,
20th, my lords, 20.
22nd,
My lords, the connected matter, the writ appeal is
20.
listed on 20th.
Letter
20,
It's okay.
serial number 36, my lord. 36.
46, yes.
Yes, my lord. Order and challenge in this writ appeal passed by my lord. That's the reason, my lord, may be posted before the some other bench.
By my brother,
Yes, my lord.
not to be placed before the
Urgency,
bench
there-
where
date may be.
one of us into bracket Honorable Mr. Justice MIL bracket or is a member.
My lord, date may
Date will be given by the
and urgency is there. My lord.
registration list the appeal at the earliest after obtaining appropriate orders on the administrative side.
Serial number 35, my lords, a small, short accommodation.
When do you want?
Any shortest day convenient to your lordships.
3rd February,
Please.
3rd February. Just
Lords,
out of
kindly
3rd
out on 4th
February,
February. 4th February.
4th February,
Please.
as requested.
Serial number 41 and 42 minutes. Office
40.
objection, 41 and 42. Office objection, 1 week time. For office
Oh.
objection is there,
What do you-
1 week time,
Office objections shall be complied with within 2 weeks,
1 week.
within 1 week. 41 and 42, same order.
Lordships can leave, my lord. For posting, my lord, a government appeal, my lord. For posting, my lord, government appeal matter relates to the rights of the government over the Jamma Bane land, my lord. The learned single judge has passed an order for refund of the money that in relation to the trees that have been cut and sold in auction, my lord. And has held that the government is not entitled even for the supervision charges.
But it will be posted once you remove the office objection.
No, no, my lord, there is some urgency because, my lord, there is batch of petitions, my lord, relying upon this impugned judgment, my lord. The other matters are being decided.
23rd,
Very well.
My lord, we are for appellant in this case. We are NBFC Home Finance Company. Sorry. NBFC Home Finance Company. We had provided a loan and we have not due to non-repayment loan, we had taken possession of the property. The respondent in this case had challenged the order and they, the honorable single bench had ordered us to give the possession to the respondent. We cannot hand over the possession because, my lord, it is involved as a public money, my lord. We had given the provided loan to the
on
respondent.
posting of the appeal.
Yes.
Appeal will be posted on 7th February.
Sounds.
Your lordship's kind leave, may I mention serial number 23, my lord?
Yes,
My
Serial
lord,
number?
this is the 23.
23,
Please, your lordship.
23, yes,
My lord, this is the contempt proceedings. I am for the complainant, my lord.
yes.
My lord, it is duly complied, my lord. Accused have also served a copy of the complaints affidavit. It is complied, my lord.
You are for complainant.
Yes, please, your lordship. I am for complainant.
Learned advocate, Miss so-and-so for the complainant states that the order under contempt is complied with. In that view, it is the statement coming forth from the side of complainant that the contempt petition does not survive. Dismissed as the petition is dismissed as not surviving.
Grateful, ma'am.
May I make one serial number 25 on that complaints made by the respondent on that it becomes in practice on that.
You are for whom?
I'm appearing for the complaint on
Same order, identity. 20.
that contempt number 1200 on that. Please, mother. Please, mother.
And permission, so contempt matter, serial number 1.
Please, Master, appearing for the
Petition
complainant.
number 80.
My lords,
Lords, in this matter, my lords, although we have filed a compliance affidavit, my lords, the as per the instructions of the deputy commissioner, my lords, the site allotted to the complainant, it falls under the forest land. Now, there was a meeting that was conducted between the deputy commissioner, complainant, and the forest department. My lords, some time may be granted. We are finding the sites to allot in a non-forest area, my lords. It is only 20% of
But it's in
lands
the
are
connected
there.
matter, it is more than enough because your contempt is time bound. What the council of the government.
Please, my
says
lords.
is more
Please,
than enough for you because you're.
They are,
contempt-
they have already complied, or they have already complied with the order passed by the already single judge.
We
But
know
the
that,
possession is,
but the
possession is,
land is in forest area.
Yes,
They are
please.
reconsidering it.
please, my lords, the connected matter is on 29th. Connected matter,
No connected, man.
no, my lords, the common order was passed. There are two petitioners.
Maybe.
It's on 29th. The matter may kindly be posted on 29th, my lords.
So are you accepting the stand of the government or we should pass the order? This is time barred outright.
Well,
This contempt is time barred. But since the government is responding to your case, very good.
May please, members. Only thing is, as far as the government contention is concerned, they have not handed over the position, my lords. Only Hakkupatra, there is a specific direction by the honorable single judge to, my lord, to put in position, page 33.
The order and the directions brought under contempt jurisdiction was passed by a single judge
02.
on 16th
What do you
March
got, compliance report?
2022. Cooperative direction provides that the Deputy Commissioner, Chikmagalur District, Chikmagalur, will consider the representation of the petitioner after conducting necessary inspection. Decide the request of the petitioner about the
Forest land.
allotment of site.
Put in position, my lord.
It transpires from the record that on 15/5/2023, an endorsement was passed. Communication was sent, not endorsement, by the additional deputy commissioner to the deputy conservator of forest. Which was a land ultimately found to be falling under the forest area.
Forest land.
Full stop. And the present contempt petition, sub comma, paragraph, learned additional government advocate. Srimati Pramodini Kishan stated that the issue is being reconsidered. By-
Please, my lords. It was
By,
by the Deputy Commissioner, Forest Department, as well as the complainant. There was a meeting
by
and
the,
proceedings.
by the authorities, including the deputy commissioner and the forest officials. And the meeting is held in the presence of the petitioner.
Please.
Only thing is, my lord, is to put in position. Last time it so happened, my lord, they're poor agriculturists, they cannot be take position of the land. They say, then there's a dispute between these two. They have to put in position. That's a specific order, my lord, to put him into position. Let them put in position the
Any of
complaint.
the paragraph, developments taking place at the end of the governmental authorities, comma, this contempt petition is disposed of by observing that the process of consultation and the alternative land, as may be, comma, shall be taken to its logical end within 8 weeks from today.
Obliged.
Please.
We have revived your dead.
I'm grateful. That will help the poor agriculturists, man. Otherwise, they cannot take position. That's all. Most greatly obliged.
Question number 2. Sir Rajkumar.
Lordship, in this matter, the accused was directed to conclude proceedings within a period of 2 months from the date of receipt of.
Filed after 1 year.
Your Lordship?
After 1 year, it is filed. The order
Yes,
is-
Your Lordship. There has been a delay from my end.
There is no delay. It is either maintainable or not maintainable.
Lordship, there is
Contempt
only
proceeding,
a
there is no delay. So 30th June is the order. What is it?
30th June is the order, Your Lordship. For the BBMP accused authorities to conclude the proceedings within 2 months.
Within period of 2 months.
Yes, Your Lordship. Your Lordship, page number 19 may kindly be seen.
August 23, 30th August 23, cause of action arose
Yes, Your Lordship. There is a delay of 24 days.
in September 20.
Yes, Your Lordship. There is a delay of 24 days. I admit to the delay.
Your Lordships, I appear for the accused. I filed wakalats recently, Your Lordships. A short accommodation may be given. I'll seek my instructions and I'll make my submissions, Your Lordships.
In some cases, you must file your argument rather than wakalati. At the request of learned advocate, so and so, then or 7th of July, 7th of February.
Well, with 7th of February. But greatly.
Question number 3. Shri Rajshekar.
But reservation to the physically handicapped for group A and B was directed to be considered at page 44.
Notice returnable on
I'll take out notice, please.
10th February,
Lordship.
10th February.
Please.
Number 4. Shashikant MP. Number 4.
If nobody is present, then it will go to 29th January.
I'm sorry.
You are there.
Please.
This is also time barred.
Time not strict.
No, it's not time barred. For this reason, my lords, the direction was issued after the order was passed that we should not be terminated from service during consideration of our case. Now, my lords, the page number 88, my lords, the order is issued on 3/10/2024, relieving us from, my lords, our duties. The, my lord, time period starts from this day, my lords, because there was a direction not to relieve.
You were relieved on 3/10/20.
Yes, my lords. Page number
What is the
88, my lords, is the
The
order.
direction is to give implementation of the government order, my lords, but however, time is not stipulated.
We'll take a lenient
Obliged.
notice written above.
Para 5, my lord, there is a direction that we should not be relieved.
11th February.
Please.
This number 5.
Again, there is no time limit.
Lords, for consideration, lords, I am not before this court. Because there is a direction not to relieve, we are relieved, lords.
They want to be absorbed. Or they are
The issue is under consideration.
difficult now to grant in any way. Let us
Obliged.
Please.
This number 5. Mr. Venugopal.
I appear for complainant. The direction of the learned single judge is at page 16, my lords. It is a implementation of the order passed by RERA, my lords. The direction is to proceed with the recovery certificate, my lords, issued.
notice written.
Please, ma'am.
11th February.
Number 6. Mr. Chandrasekhar.
Appearing on behalf of complainant.
It is written on 12th February.
Number 7.
Same matter. Same matter, my lords, with regard to release of compensation amount, my lords, having acquired the property, my lords.
But
KIT,
also, there's no time
There
stipulated.
is no time limit here, yes.
please, my lords. Order was passed on, my lords, 1st October 2024, my lords.
The operative direction in order dated October 24, passed by learned single judge while disposing of the petition, which are brought under contempt jurisdiction. Read as under inverted comma, ... a direction to Miscellaneous. Full stop. A bare reading of the aforesaid direction show that time limit is not prescribed by learned single judge for compliance. Full stop. In that view, it is not possible to conclude at this stage that any of the respondents have committed contempt of court, much less a willful contempt. At the same time, it would be tried that the directions of the court do not go uncomplied with. Therefore, it is provided that the exercise contemplated and directed as above by learned single judge will be completed by the authorities within period of 3 months from today. Full stop. The contempt petition. Case shall be completed within 3 months. Full stop. The Tahsildar shall act within 1 month, and the respondent 3 shall thereafter consider the case within 2 months from the date of the consideration of the case by the Tahsildar.
Great.
Still number 8. Mr. Srikanth.
There is delay, my lords, in,
Petition is disposed of accordingly. Now,
there is delay, my lords, in instituting petition. Lords, direction, lords, annexure G is the order
next
of
step.
the learned single judge, my lord, directing, my lords, consideration of the proposal within 8 weeks, that is 2 months. Nothing has been done, my lords.
Appears to be time barred.
Yes, ma'am, but that is there, but lords, fact remains that we made proposal, my lords, nothing has been done on their part.
Just find out. Find out. We are not receiving none. Find out what is happening.
Obliged.
Your end. Learned additional government advocate, Srimati Promotion shall apprise the court about the status of the compliance status of the subject
Please.
matter. Send over to when, Madam? 31st January,
Obliged.
31st.
Seal number 9,
4th February, 4th February.
seal number 9, Ashok.
My lords, in this matter, the your lordship, respondent number 5 took an admission illegally.
It is returnable on 12th February.
Much of it.
Seal number 10, to Subramania Bhatt.
I appear for the complainant, my lord.
It is returnable on 12th February. Interest. Yes.
Seal number 11,
My lord, your lordship had passed an order giving them 6 weeks' time to comply with the order of the single judge. This is with regard to the terminal benefits payable to the workman because of his thing, my lord.
Plans of the direction in this case. Prima facie appears to be an aggravated contempt inasmuch as earlier contempt petition was filed and this court directed the authorities to comply. The order of the court time bound. Still,
Yes, my
however,
lord.
there is no complaint.
6 weeks' time has elapsed, they are not
It's
compliant.
returnable on 4th February, full stop. It is expected that on the returnable date, the respondent shall take a stand of compliance, failing which a serious view will be taken. Next.
My lord, next is the same, another worker.
12,
It's the same, my lord. 12 is also the same.
Which one?
The next one, my lord. Next contempt 12,
Next.
same
contempt is not-
management, same order.
It doesn't appear to be same.
12,
How it is same? It is not same, Mr.
My lord, page number 33, my lord. Page 33, my lord, your lordship has passed an order, my lord, giving them
It's same.
6 weeks' time. Same management also
Same order.
same. my lord.
Same, you are right, same order.
PL matter, seal number 13, PS Nagaraj.
The petitioners are all villagers of P. Vasalli, Srirangpatna Taluk. And in the year 2015 also, they have obstructed the road, public road. And the Tahsildar was removed it, annexure C, page 40 method. The English version is page 41. And again, they are doing the same thing by obstructing and cultivating the land. Respondent number 9 is the adjacent owner of the road, land owner. He is cultivating by removing the road. My lord, I have made the application to the deputy commissioner. Deputy commissioner still is not taking consideration. We are all the villagers made the application.
Will direct and dispose of. Third, learned advocate, Mr. So for the petitioner and learned additional government advocate, Srimati Neelapur Akbar, who appears to assist the court upon service of copy of the petition in advance. Petitioners happens to be the residents of the village Hosahalli, Srirangapatna, Taluka, Madhya district. By filing this petition, style public interest petition, straight paragraph. Is to direct respondent to deputy commissioner as well as respondent for Tahsildar to take necessary action to clear the road, to make the ingress and outgress convenient to the public by considering the representation dated 24/9/2020 made by the petition. The petitioner further wants paragraph respondent 2 to 6 authorities to take action as may be necessary, under the provisions of section 192 capital A of the Karnataka Land Revenue Act and other laws in respect of the alleged encroachment of the road. The case put forward, paragraph in the petition is that Oh, notice. Taking steps. Returnable on 12th February. The grievance, though may not be amenable to our jurisdiction, but appears to be grievance because it appears to be justified because earlier the Tehsildar had removed the option.
Yes.
Learned additional government advocate, Srimati.
Allowed for respondents
Accepts.
1 to 6 and 8.
Notice on behalf of respondent 1 to 6 and 8. As well as respondent by 8. Yes, next.
Number 14. So Sadanand ji.
To appear for the
Now,
petition.
why you are making the number 2 as part? You first delete. Number 2 is not relevant, not necessary.
Yes.
First
I'll carry out the amendment today itself. Now, my lord, one incumbency for the last 2.5 years, the SC/ST
Sir,
commission.
after you delete number 2, we'll consider.
And now only immediately I will do it. Today itself I will do it.
Maybe 20.
Maybe permitted also file a memo to that effect.
Yes.
Now, my
But-
lord, for the last 2.5 years, the SC/ST commission does not have a
Unless you
chairperson.
delete number 2 from the array of the parties, we are not going to listen.
2:30 PM, my lord, kindly.
No, Monday.
Grateful.
Number 15, writ appeal.
My lords, in this matter,
This is to be admitted and heard.
and my lords, we seek a stay also, my lords, that is,
Can we?
my lords, the provision has been struck down, my lords, by virtue of which, my lords. Your Lordship, I'll just make the 128A was upheld already, my lords.
Earlier it was upheld.
Upheld, my lords. And subsequently, only on the short point, when the violation of fundamental rights is being affected, my lords.
No,
Yeah.
because if virus was, it was held intra-virus.
Yes, virus was upheld.
Then why this again
But-
petition was?
But at that time, my lord, it was not a fundamental right. Now the constitution has been amended
What is?
and it has been made as a fundamental right, my lord.
What?
Under Article 19(1)(c), my lord.
What is fundamental?
But to form and manage cooperative societies, 19(1)(c), my lord.
No,
Your Lordship, kindly see the,
And
not to manage, my lords. The right
not to
form a-
mismanage, my lords. Manage is a
But the-
fundamental right.
whatever it
Then-
may be,
then-
my lord, I will get ready for hearing anytime.
Where is the provision line?
Your Lordship, may kindly see the petition.
And if stay is granted, my lord, nothing survives. My lord, it will be virtually allowing. They will start appointing. So far, my lord, the appointments were being made by the cooperative societies only. From the very beginning, since the days of independence.
What is this page 65, running page number? Your Lordship, running page number is already there in the appeal memo. Running page, internal page 65, my lords. 77 of the appeal memo.
Nine.
14.
We are supporting him.
My lord, there's a misappropriation of funds more to the tune of 1,400 crores by the CEOs, my lords, of this cooperative society. And one more thing, my lord, state is not controlling anything, my lord. It is a federal society which is taking care of the primary cooperative society.
How the 128A is constitution of a common cadre.
Please, my lord, can I read 128 for just for a moment?
It is struck down.
That has been struck down, my lord.
What ground?
Fundamental right is violated, my lord.
Fundamental.
19(1)(c), my lord. My lord, your lordship, one submission, my lord. Today, my lord,
For a change, my lord.
applications are, my lord, there are several
Let
implementing.
us see the, no, we'll consider, but prima facie, we.
Madam, prima facie, my lord, your lordship may kindly give me some
Not
date,
concluding,
my
but-
lord. I will argue, my lord. Some date, my lord. Today,
we'll-
but I thought only impleading applications, my lord.
So in what way this offends fundamental right?
My lord, formation, the right to formation my lord, also includes, my lord, to right,
Does that right?
the right to appoint its employees for any union and all that.
Correct, but that right is not taken away by, is it taken away by this?
No,
It is taken by the amendment.
no.
What way it is?
Not,
taken?
kindly see what is the section now, which they have introduced for the first time, so radical. Kindly, my lord, page, my lord, writ appeal papers, page 142.
This is only regulatory.
That's all, my lord. That's it. my lord.
Page, my lord, page 142, my lord. Not only that, there are several decisions, my lord, according to me, it is fully covered. But page 142.
Very
my lord.
section 128.
Kindly
was-
see what will be its effect if the stay is granted, notwithstanding this, anything contained in this act, the rules or the bylaws, where the registrar, in the interest of the cooperative movement, considers that the creation of a common cadre of employees for any class of cooperative societies is necessary, he shall authorize one or more federal societies to which such a class of cooperative society is affiliated to exercise the power of appointment, transfer and disciplinary action. So they will be virtually made government employees. These employees of the cooperative societies will be made government employees.
No.
All that left to us is to pay their salaries.
No, my lord. That's it.
Except that, my lord, nothing is left with us. I will file my objections, my lord. We will argue the.
My lord,
in
there is
any time. But in
misappropriation.
fact, once this is permitted, my lord, which for the first time this section is introduced. My lord, for a brief period earlier it was introduced, it was deleted. And these cooperative societies will be ruined now because it will be go to the government control. Now, once this section is struck down, my lord, it is not a case for grant any interim order. Now, kindly see what are the other amendments, my lord. Whole chapter is included to the constitution, but to make it more liberal. Kindly see, my lord, the next one article, my lord, article 43B, man, 19C and 43B. The state shall endure to promote voluntary formation, autonomous functioning. Article 43B.
The state shall endeavor to promote voluntary.
Yes,
formation.
autonomous functioning, democratic control and professional management of the corporate.
It's democratic control.
But no, autonomous functioning, madam. Autonomous functioning includes the right to appoint. Madam, that is laid down. But the Honorable Supreme Court in TMA's case, my lord, has said autonomous functioning includes the right of appointment. But there are several autonomous bodies now. And all these autonomous bodies enjoy the right of appointing their servants, its employees. Now, for the first time, this section is introduced. My whole submission, it is only for political considerations. My lord, it will be virtually taking over the entire cooperative societies, my lord, by the government. All that is left to me is now, my lord, if they take all these rights, I have to pay the salary. The entire control is by them, and it will become a government department. Therefore, definitely, my lord, my humble submission is this is not a case for stay at all. Now the learned single judge has passed the section, and if, my lord, a stay is granted, But they will immediately appoint. Once they appoint, start appointing and all that, the entire thing becomes infructuous. My writ petitions become infructuous. I am ready for argument at any date, my lord, subject to your lordship's. And today the matter is, my lord, the several impleading applications all returned with office objections. But if they, I do not know, my lord, how for the writ appeal, my lord, strangers who are not party to the writ petition coming and filing, I have not received copies.
You are original respondent.
Pardon me.
Original petition.
Impleading applications, my lord.
Who is original petition?
I don't know, my lord. I have not received application.
Petitioner.
Pardon me.
You are the original.
I am the original petitioner. I am the original petitioner, writ petitioner, caveator.
I don't.
Applicant, one of the applicants brought, the applicants are all
Federal
DCC banks under whom these societies function. It is not as if, my lord, the entire staff of the cooperative societies is being appointment or recruitment is made. It is only particular category, that is the chief executive officers of each of the societies. There will be common killer. This is because large number of societies under our jurisdiction, there has been huge misappropriation of funds, crores of rupees. And we are the link between the NABARD and other institutions lending money to these societies for less interest. So unless we have some control, it has become very difficult to manage. Therefore, it is not as if the entire cooperative society staff is being appointed, Lord. Only the chief executive officer of each society, there will be a common cadre so that there is control over the management of these societies, particularly relating to financial matters. And earlier also similar provision was there and it is upheld by this honorable court. Now, the only difference is pointing out is forming of a cooperative society, that is the amendment. And 43B, as your lordship knows, it is in part 4 below, not any other provision. And identical provision is upheld by the division bench of the Madras High Court. The learned single judge has said that he doesn't wish to follow
that, and the principle of reciprocata is totally ignored, man. And Malot, page 166, 1,430 crores of misappropriation of funds. They want, we are concerned with only CEOs. It is state has no role to play. It is between the primary and the federal. The primary are affiliated to the federal. You regulate yourself so that there's some kind of control. And as your lordship pointed, it's only a regulatory mechanism. Malot. We are not taking over at all and not even controlling them. Malot, in TMA, even though Supreme Court has a right to admit and administer is with the institution, NEET has come into place, fee structure has been done. These are regulatory mechanism, Malot. So therefore, Malot, by virtue of this, the primary society wants, the idea is to see that there's misappropriation of funds, of public funds, Malot.
My lord, the section doesn't say, my lord, it is only for executive.
The original petitioner is not there.
Please,
I am the petitioner, my lord.
That is what we are asking.
I am the original petitioner.
I just want.
I have entered caveat. And in fact, my lord, there are about 30, 40 cooperative societies, not one. Today, my lord, they have filed the appeal challenging the only one not. Kindly see the order of the learned single judge. How many cooperative societies are there? This method, my lord, there are about 30 and several to be disposed. They have not filed appeal as against the other orders at all.
Let him argue.
Only this. What arguing, my lord, I am ready, my lord. If your lordship may kindly fix any date, man. I said it in the beginning. I am only opposing the stay at this juncture because it will render the entire work futile. There are thousands of cooperative societies, my lord. Even if tomorrow advocates form a cooperative society, employees will be appointed by the government. Such an important thing, my lord, under Article 19, such a fundamental right which is very, very essential. It is the, your lordships are well aware, my lord. 3 articles are said to be the trimeratives. One is Article 14, 21 and Article 19. And in 19(1)(c), a very fundamental right, my lord, to form our own association. We pay it, we manage it. If they start doing this, my lord, it will, and for the first time, this allegation is made.
No, the part of the petition.
It has not been, no objections were not filed, details, data has not been furnished. My lord, what they say is from amount coming from NABARD is misappropriated. NABARD will take action. They need not give it to us. I submitted before the learned king. We do it, my lord. Cooperative society is a self-help group. We make it for our purpose, my lord, a local group. My lord, they take assistance, our assistance, my lord, to see that these funds are reached or distributed. We are not asking them now to coming and to say that that amounts are mismanaged and therefore we will appoint your corporate employees. My lord, it will be whole ruinous to the cooperative society.
Lords, I'll just add.
Definitely.
Lords, that was not never the scope, Lords.
That was the scope. That was
Section 128A deals with only with certain categories of employees of a primary society being regulated by the federal society. Lords, federal society has its members as the primary society. There also it lays down the checks and balances that registrar will have to notify only certain classes of societies. Not the registrar has notified only the credit structured societies. Notice what it says is, wherever we are all credit structured societies, wherever the money flows from the federal society to the primary societies to be disbursed to the members who will be the ultimate beneficiaries at a very low interest rates, there is an obligation to ensure that certain safeguards are to be maintained so that the recovery process is there. Because there is a flow mechanism, Lords, from NABARD till the end beneficiary. Lords, now what we brought to the notice of the government is that at the end of the primary society, since there is no control, disbursement is taking place without any guarantees and there is no recovery virtually. And ultimately the primary societies is coming and saying that we have initiated proceedings, no money.
That can be checked by this provision.
Yes, but this is essentially what was done under Section 128A.
How?
That's what Section 128A seeks to achieve is, it now categorizes certain categories of employees, more particularly the CEO. Now he is responsible for the purpose of vetting all the decisions for disbursement of these loans in favor of
One
the credit
example,
sector.
if I may intervene, my lord, one example, my lord. If a person sits in one cooperative, there are 200 cooperative society primary affiliated to one federal. If one CEO of 200 CEOs, my lords, are sitting in only one place, my lords, he's got the whole system in control, my lords. There's no transparency like bank manager, my lords. They transfer the bank manager from so that he's not in control, so that the transparency is there. So what they're doing is, as of now, what we are concerned immediately, my lord, rules have not yet been framed. Before the rules of whatever my learned friend argues, an apprehension likely to happen, the petitioner, my lord, saying that we are state may take over. All that is not going to happen. We'll frame the rules. If the rules, by virtue of which any right of the cooperative society is affected, that will be set aside, my lord. We are not going to interfere. It is only a regulatory mechanism.
Amendment Section 128 doesn't vest any power with the state to take over the employees, my lords. That's not a correct
man itself, my lord, with
Lords,
that most
it only
respect.
vests the power with the federal society.
No, granting of in a relief will amount to allowing the appeal.
And my lord, this method also, their method, my lord, there are 40 writ petitions, 45 writ petitions disposed of by a common order.
Can I make a request?
So far, government has filed only one appeal. Kindly see, my lord, they will all engage, your lordships will get the better assistance also. 45 writ petitions disposed under this. Only one writ appeal against one cooperative society has been filed and they are pressing for a stay.
Can I make
All these people are, and somebody are trying to intervene in that.
Can I make one request?
Impleading applications after impleading application.
Can I request?
All these societies should be impleaded.
Lord,
They have got a right to be heard.
Impleading applicants are the federal societies under whom these cooperative societies are functioning. We are the link between the NABARD, which is providing funds, and disbursing to them. Through us, it is being done. Now, under my jurisdiction, my lord, one DCC bank, there are 243 societies.
So you are federal society.
Federal society.
We are appearing for the federal societies which are aggrieved. And my lord, it is the responsibility of the state.
You are not there.
Lords, what happened before the learned single judge? Federal societies were permitted to argue as intervening applicants. So the same status may be continued. I don't want to get impleaded. As long as your lordships is giving us a right of audience, lords, we are grateful.
Page one, can I make one request? At least, my lord, your lordship may kindly permit us to frame the rules and place it before your lordships, my lord. Permit us to frame the rules under 128, place it before your lordships, my lord. So there is ultimately your lordships are suing whether it is violating their fundamental rights. 128 reading by itself, which is already upheld, your lordship may kindly see, my lord, identical provision by the state has already been upheld. So therefore, my lords, unless the rules are framed, your lordships will not know. Permit us to frame the rules, and this let common cadre committee work only insofar as CEOs are concerned. There are other attendants, first division clerk, second division clerk. We don't want to touch them. Only the CEOs, Manoj, in the interest of financial reasons, Manoj, because there are large scale misappropriation, Manoj. Only insofar as CEOs, like, kindly let us operate this.
Madam, to grant any, my humble submission,
No,
madam,
my only-
grant any interim order, my lord, they have to challenge the entire orders here. But this is connected and cooperative. All the societies will have to be heard. I have no objection, my lord, for anybody arguing and all that.
Only for
They will
limited,
have to be heard. They too have an order in their favor.
your lordship may limited
This
stay may
method,
be-
once if this interim order is granted, confining it to only one appeal, well, not everybody, the benefit will be, they will form the rules and other things. Basic thing.
Manoj, I'm-
But I,
But to a
I-
greater extent,
I appear for one of the federal societies. Same, I'm supporting the state. What the learned advocate general appears to be submitting before your lordship is 128 capital A words contemplates regulations to be made by the state, which would show whether there is actually an encroachment upon the autonomy of these societies. If a draft regulation is placed before your lordships, and if lordships find that they are really do not encroach the concerned cooperative society's autonomy, then there would be no cause for concern. It would be my limited submission.
And one submission, my lord,
Okay.
the cooperative societies themselves have no fundamental rights. The right of the individuals who become directors and entire management, their position is not at all touched by this amendment. And the similar provision, verbatim similar, has been upheld by this court earlier. Only difference
Your
is
lordship may kindly see the
pointing out
judgment of this.
that
Milords, in Daman Singh's case, the law is very well settled, Milords, that member doesn't have an individual existence or right under Article 19(1)(c).
Yeah.
Once it is regulated under the Cooperative Societies Act.
But that's all a matter for
Yeah, okay,
argument. We will argue it in detail. The only for the question of consideration of interim order only now. Cooperative society has no fundamental right, but citizens have the fundamental right. Members have the fundamental right. And there is an order in my favor. And we are, my lord, we are concerned with the validity of the section. The section is very comprehensive. Today they may frame one regulation, tomorrow they may change it. We can't, my lord, it is, my lord, this section which is now introduced is so comprehensive, it gives them every power. We are, my lord, concerned with the legality of this section. Therefore, my lord, regulations will come and go. My lord, today, the section doesn't say it is only for the executive officer and all that. All employees, it says.
No, class of employees.
All class of employees, not the employees, all employees.
That is yet to be notified.
if a particular regulation is bad, that could be challenged.
It will be a shot in the dark, Milords, the manner in which this challenge is laid.
Let, my lord, them file appeals.
Free advice is being given.
Well, it is their natural right. They will have to be heard.
A, allowed provides for common cadre in respect of allowed TCARD banks. Allowed this system is already working. 97A, allowed so far as the PCRD bank is concerned, there are also primary societies and allowed already a common cadre is there. 97A, similar provision is already there, my lord.
Heard, learned. Speaker and safety. For the appeal. State. of Karnataka and learned advocate Mr.
Keshav Bhatt,
Keshav
Keshav Bhatt for caveat.
for original petitioner on caveat. In respect of the admission of appeal as well as grant of interim relief or otherwise. The challenge in this writ appeal is addressed to judgment and order of learned single judge passed in common in disposing of different writ petitions whereby learned single judge has by allowing the plurals of the original petitioners held that section 128 capital A of the Karnataka Cooperative Societies Act 1959 is ultra vires the Constitution of India, and accordingly it is struck down. Full stop. Section 1, paragraph 28A of the Cooperative Societies Act, Karnataka Cooperative Societies Act 1959, which is the validity of the constitutional validity of which is a moot point in this appeal, reads as under, then quote section 128A. Full stop.
And interim order was there
Two arguments
during
were-
pendant to the writ petition.
Interruption during the course of the dictation of the order will not be tolerated. Please take your seat. Yali. What did you write? While assailing the judgment and order of learned single judge. Three main contentions were advanced by, on behalf of the state. Firstly, that the provision of section 128A of the Act in its nature is a regulatory provision intended in the large interest of cooperative movement and seeks to cure the ills which have flourished in the working of the cooperative societies. Secondly, it deals with a particular cadre of the employees to be appointed and regulated under this section by framing rules and bylaws. Thirdly, it was stated that earlier the provision was held intra vires. However, this time learned single judge has taken a different view, treating it to be violative of fundamental right to form the association and to form the cooperative societies. On the other hand, learned advocate for the original petitioner caveated submitted by highlighting that right to form cooperative society is part of the fundamental right under Article 19.
1C.
1C, and he further relied on Article 43, capital B of the Constitution, which, however, falls under Chapter 5, Chapter 4, under the head, the directive principles of state policy. It was submitted that the provision in its operation and effect takes away and abridges this fundamental right. Therefore, learned single judge is justified in striking it down. Paragraph. The issue requires consideration. Finally, therefore, the appeal is admitted. It shall be listed for final hearing when? On 3rd March?
Please.
Or
3rd March. Please, ma'am.
3rd March.
3rd March.
3rd March. Full stop. As far as pressing for interim relief, learned advocate general submitted that since on the face of it, the provision is regulatory in nature and would fall within the reasonable restriction contemplated under article contemplated for the fundamental right under the constitution, comma, the same, the judgment and order may be stayed. Full stop. The request cannot be exceeded to inasmuch as staying of the judgment would amount to allowing the appeal at this stage and granting principal relief, which is not permissible in law. At the same time, the paragraph, the request made on behalf of the appellant for permitting the state to frame the rules and bylaws
Please,
for the purpose of
section 128A.
section 128A cannot be said to be unreasonable. Full stop. The state authorities is permitted to act to the limited extent under section 128A by framing to frame the, what is that?
Regulation. Draft regulations.
Rules and regulations.
Petitions.
Rules and bylaws. It is however clarified that the rules and bylaws which may be framed as per the permission granted herein shall remain at draft stage and shall have no legal efficacy until the appeal is finally decided, which will be subject to the final outcome.
The only thing will, your lordship may kindly, I'll let it be at the draft stage, sir. Please, my lord. Please. And your lordship may direct us to place it before your lordship so that your lordship while examining that. Okay, I will, anyway, we'll place it on the next date of hearing on 3rd March, the draft rules, my lord. So that your lordship may consider.
You can place it.
Place it.
You are permitted to.
Please. The impleading application, I think we have no objection, my lord.
That must, yes.
We have no objection.
They have not served copies.
About that.
They want to be
My lord,
heard.
About that.
My lord, I am the appellant, my lord. I have no objections.
One more order below, then order below. This is what, number 15? Order below, there is delay also,
15 days.
15 days. That
all
may be
all are
fine.
appearing, and
That
order
can-
below IA number 1 of 24. This interim application is filed for condoning delay of 15 days, which has taken place in filing the appeal by the state. Full stop. State is impersonal authority and the decision-making process invariably takes time. Viewed from this standpoint, the support, the governments and the supporting affidavit makes out a sufficient cause. Delay of 15 days is condoned, application is allowed. Then order in IA 3 of 24, IA 4 of 24, IA 1 of 25, IA 2 of 25, 3 of 25, 4 of 25, 5 of 25, 6 of 25. Paragraph. All these IAs are the applications filed by the applicants who seek impleadment in the proceedings of the appeal. The applicants are the federal societies, full stop. The issue involved in the appeal is the constitutional validity of section 128 capital A of the Karnataka Cooperative Societies Act 1959, full stop. In the subject matter, it cannot be said that in the subject matter and in the outcome of the appeal, the applicants federal society do not have any interest, full stop. Their stand is relevant and material, full stop. It was stated that during the hearing of the appeal, during the hearing of the petition before a single judge, the present applicants were permitted to intervene and put forward their case, full stop. All these in the above view, all these applications are disposed of by providing that the applicants shall be permitted to be an intervener and raise their arguments in relation to the subject matter controversy.
Madam, there are other 3 respondents, madam. Notice is not ordered to them.
Then we will not be able to even condone the.
No, my-
Because
We'll take our hand summons on those.
they are parties, my lord. I entered keyword only for the first respondent society.
Kindly permit us to serve on the.
So that notice to them and
So don't pass any order in delay condonation.
Please,
So the above order is passed pending the delay condonation.
Please.
Full stop. There shall be,
Notice in the writ appeal.
shall be notice in the appeal as well as delay condonation application to the
Unserved.
respondents who are not represented by any of the advocates.
Please.
Which are respond number?
224.
224.
Can I make one more request?
End delivery is service by end delivery is prohibited. Full stop. For the limited purpose to ensure that all the parties appear and file their wakalatnama, and that the delay aspect is adverted to, the present appeal shall be listed next on. We'll say, when you will serve, 29th of January.
Please, madam.
Thereafter, we'll keep it on.
My learned friend had appeared, I think, my lords, for all of them.
If possible, I will. But I had appeared in the.
Sir, do appear and waive it.
I will try, my lord. I will try. There is no. I will. But still.
No, we direct you.
I'll give, outside the court, I'll give to him, my lords.
So forget all the original word is correct. Learned advocate Mr. who so and so appears on caveat on behalf of number one is directed to appear on behalf of all the.
Very well, very well.
So delay is condoned, everything.
So hearing on third, my lord, third.
Now third.
3rd of February. Very well.
No.
March.
March.
Refer to my lord.
Till number 16, Mr. Ravi Shankar.
My lord, I appear for the petitioner. On the last date, the court had ordered the respondents to file replies. They have not filed.
Lord, this may
It
be
looks,
called along with WP 710 of 2024. It pertains to the Madrasa, my lord, adjacent to the Juma Masjid. This also pertains to the same. It's posted on 17/2.
It is not same, but we still be post on 7.
Lord, I will,
More or less it's the same.
Nobody is-
my lord, I'll need some time to file the reply.
Nobody is
And
file-
moreover, my lord, the petitioner wants us to conduct a survey in respect of an existing structure. The Honorable Supreme Court in that Ashwini Upadhyay case on 12th December
Yes,
has
yes.
stayed all proceedings
No, but
wherever survey of any existing structure involved. So
this is a prospective, my lord.
Get
What
that.
he's referring is
but it
prospective.
may call it after about a month or so, my lord. We'll file our,
You get that order also.
yes, my lord, I'll file.
My lord, that order is prospective, not retrospective. In this case, the state has already ordered, given directions to this, to the archaeological survey.
Today, any interim order is operating here.
No, there is no. So therefore, that prospective order will apply here. So.
My lord, since it is more or less similar, if my lord were to deal with the writ petition 710, then this will be easier, my lord.
Be listed with writ petition number 710,
Of 24 on 17/2.
17.
And the replies may be taken as, posted for the arguments, my lord, directly.
Now, I don't
They have
know
not
what
filed
this
a
is.
place as of
Let
late.
them reply will have to.
Till number 17. Mr. Ranjan Kumar K.
I am for the 16th respondent. Respondent number 5 to 11 minutes.
13 to 15 minute respondent.
17. 17. What is it about? Is
Minute,
petitioners.
this,
Some residential site are formed near temple.
Temple land.
Land has been temple land. So what is wrong? What is?
That land is endowed to the temple, my lord, the fruits of which are used for the maintenance of the temple. The Archak, my lord,
No, now, my lord, it has been made over to the developers. Respond number 12 and.
Minute,
respond number- No, it is a residential site by the developer.
after 49 years, after 49 years, minute, without questioning minute grant order, this type of PIL has been filed by the petition. After 49 years,
Who are you?
minute, I am absolute owners. I am the grantee.
Grantee.
A tribunal has been granted in my name.
And you handed over your land to develop.
Yes. No, minute. This land granted minute in the year 1976
No, no,
by way of
we are-
occupancy rights.
Trying to know the factual situation.
Yes.
You are the grantee of the land.
Yes.
Owner of the land.
Yes.
Now you have given up the land, given the land to developer for putting up, for constructing a residential site.
Yes.
JDA.
Yes.
But JDA is already produced. So what is it? If they can do that? No. Merely because it is near to temple. Now, earlier, my lord, it was exclusively given to the original grantee, my lord, to perform the sevas of the temple. Is it so? Subsequently, there was a regrant order, my lord, which was the petitioners were not aware. And they have submitted, my lord, file your reply. Replies are filed? It's filed.
No, my lord.
Filed
They
or
have
not?
filed.
Filed,
Contesting
objection.
respondents have filed.
You are, who is number 13, 14, 15?
13 to 14, 15, I am.
Who are you?
I am the landowner under the Inam Abolition Act re-grantee. He has sold the property to me 40 years
You are
back.
the owner or he is the owner?
That is one survey number, my lord. And my survey number is 1 acre,
So you
32
are-
guntas, my lord.
Your status is same.
Yeah, no, my lord, my land is been granted, re-granted under Inam Abolition Act.
Lord, there are two survey
And my
numbers.
land is converted in the year 1982. My lord, my lordship, my land is been converted.
You want to file reply?
My lord, I'll just seek instruction, my lord, because quashing of the conversion order is sought.
4th February, 4th
Okay.
March.
Right then. Number 18. LM Chidanand.
The application is rejected.
Please, on the ground, my lord, I have violated Route 3G, my lord. So there were proceedings earlier, my lord, under 3G.
Objection.
That 3G proceedings were closed.
Reply is filed or not?
My lord, I'm relying on the, no, my lord, I'm relying on the order annexure A.
Order annexure.
Yes. Page 37.
Your Ganapati granite impacts.
Yes.
Yes.
The reason is para 37 minutes, sole reason. Page 39 minutes.
My lord, it has to be read from paragraph 29, my lord, for a better understanding.
But this order is not in relation to petitioner.
My lord, page 37, paragraph 29.
Your lordships will kindly see, my lord. Rule 3G is only an enabling provision. But for any reason, if I am not able to carry out export, my lord, I have to seek the permission of the deputy director to sell locally. My lord, in this case, my lord, deputy director has granted the permission to sell locally. The proceedings were initiated earlier, my lord, and in the proceedings, my lord, the state government has closed the proceedings under Rule 3G. My lord, this 3G violation is not part of the notice. Your lordship may kindly see the notice issued to me, which is at annexure, translated copy is 160 my lord, page 160 my lord. Now this violation of 3G, my lord, is not part of the notice, my lord. If they have put it on notice to me saying that you have violated 3G notice,
Where is the notice?
annexure G, N2 my lord, page 160 my lord.
116,
Please, 160 my lord.
16.
Yes. In terms of the order of the Honorable Supreme Court dated 25/2022, as per the orders of the Honorable Court in writ petition 30 connected with so and so, in order to dispose of the application filed seeking grant of quarry lease in survey number 43 of so and so village, fix a date of hearing at room number so and so.
But you are challenging this order 26-6.
Please, my lord. Now, this is the notice, my lord,
Is that
and
order
then subsequent.
Where is the 26-6 order? Same order.
Like, without giving any notice to me, my lord. If they have given a notice to me,
Same
I would have
order.
placed, my lord,
It is
yes.
Same order, 26.
Yes. Those orders I have produced before your lordships, my lord, wherein, my lord, my application was rejected and the applications of others were granted. On the ground, my lord, my application has become invalid. My lord, I filed writ petition before this court, my lord, this court set aside that order. Let the matter was taken to the Supreme Court. My lord, Supreme Court, the order passed by the division bench of this honorable court. Then he issues a notice, my lord, calling upon me to appear. Before, my lord, in the notice, there is no reference of this violation of 3G. Your lordship, I kindly see 3G, what does it mean? 3G of the KMMC rules. Your lordship, 3G, your lordship. Where a quarry lease has been, granted on priority basis and clause 2 of sub rule 1 of rule 12, the existing before the commencement of Karnataka minor mineral concession rule 2016, relaxation may be granted by the deputy director or the senior geologist of district to the lessee to sell such part of the quarried material locally that is found to be defective, not fit for export. This is the enabling provision. Provided that no such permission of relaxation shall be required from the deputy director of the district in cases where the quantity of the minor minerals sold in the domestic market is less than 25% of the total quantity sold in a financial year. In such cases, certification by the shall be accepted.
Why don't you file? It was earlier observed. He says that the ground which is indicated for rejecting the application are not put to his notice, nor falling within rightly or wrongly 3G.
My lord, may I make one submission? My lord, before the coordinate bench of this honorable court at page 162, this contention had been taken at page 177. He has now raised the ground in this writ petition saying that, my lord, no opportunity of hearing had been given to him with regard to this violation of rule 3G, though all along, my lord, his contention was that. Now, if my lord were to say, issue a notice, my lord, incorporating, my lord, for technical purposes that there's violation of 3G, I leave it to my lords. Because their contention has been that.
Page 160.
162.
162 judgment starts.
Yes, judgment starts. my lord will get it at. My lord, page 177. My lord, if my lord may come to 4 sentences from below. He invited our attention to Rule 3G of the said rules of 1994 and submitted that the provision regarding relaxation has been introduced to suit the needs of Ganapati granites. My lord, that has been, it's not as if, my lord, they were caught unawares. They knew. But now if he says that, my lord, technically it was not mentioned in the show cause notice because of which, my lord, they were not able to my lord, put forth their contentions, then I leave it to my lords.
My lord, Rule 3G, my lord, pursuant to this inquiry was held, the inquiry is closed against me. My lord, under sub-rule 3G, my lord, if I have violated, my lord, they are entitled to cancel my lease, my lord. My lease is not cancelled in respect of other leases. My lord, if he has put to notice to me, I have produced the earlier order passed by the very secretary, wherein, my lord, the Rule 3G is only enabling section, my lord, if for any reason I am not able to export because of the defect, my lord, I have to take permission from the deputy director for the local sales, my lord. It doesn't enable them, my lord, to reject my application which has been filed for grant of quarry lease, my lord. It's absolutely.
We'll go through the earlier one. 26.
My lord, and
20.
my lord, why are they filing shy of, my lord, when we want to conduct a auction? If they are the highest, my lord, bidders, they will get it because they say that they are 100% export oriented units.
My learned friend is, their own rule provides for grant of quarry leases, my lord.
Now this 160, page 162, order was in his own petition? No.
My lord, he's been a party. My lord, 12700 of 2019, page 164.
127.
It's not as if they were caught unawares.
That has been set aside by this court, my lord.
What?
That order, your lordship, Mr. Satish, my lord, the grant of quarry lease in my favor is challenged by Mr. Satish. The allegation is, my lord, that I have violated Rule 3G, my lord. This court said, my lord, kindly see the operative portion of the order, my lord.
Yes, yes.
It is at page, my lord, my learned friend, my lord, is arguing as if, my lord, the 3G, my lord, if I have violated 3G, my lord, then they can cancel my lease which has been granted to me. That is an enabling provision. By relying on enabling provision, can they reject the application contrary to the order passed by the revision bench of this court, my lord. 194 is the order, my lord. It is in respect of other applications, my lord, filed by Satish.
My lord, the submission was, they were not put on notice with regard to Rule 3G.
My lord, this has been, my lord, inquiry is held, it is closed, my lord. You kindly see the order of this court.
My lord, page 26, paragraph 26 of the order may be seen. Last sentence. Page 190. It's not as if they were caught unawares. Paragraph 26.
My lord, if there is a cancellation of the lease, my lord, they have to follow Rule 6.3, my lord.
We'll just go through.
If there is remanded, my lord, I will produce. I have not violated Rule 3G, my lord.
Take up on 29th of January.
Oh, yes.
Please.
We have to say whether that he is put to notice about 3G.
3G, they were, all along it was the contention and
I'm very sorry, my lord. Current government advocate should place and record your lordship, my lord. No notice is given. Suddenly, bolt from the blue in the order, I come to know, my lord. By relying on 3G, my application is rejected.
My lord, that could have been brought to the notice of the government, my lord. At the time, the arguments were being heard.
Petition.
My lord, earlier petition, my lord, yes.
Page 162.
So you are not only aware, but
Yes. My lord, no,
They could
sir,
have brought it to the notice of the government, my lord.
Inquiry was held, my lord,
Page number 39 of your writ petition,
39.
39. The findings held against you.
No, my lord, that was challenged before this court. An inquiry was held and that inquiry, 3G inquiry is closed, my lord. I am operating those two mines which they say that there is a violation.
page 39.
Please, 39, your lordship may kindly see, my lord.
See,
Is your lordship,
you yourself made a representation, you can't make 100% export.
because it is defective, it provides, my lord, rule 3G, my lord, if the granite blocks are defective, if I am not able to export, my lord, the deputy director.
That was
has-
not your representation according to this.
my lord,
You
if-
made a representation to the director, DGM, wide letter dates also, explaining your inability to carry out exports by shifting the quarry produce to its 100% EOU and wanted relaxation from complying this requirement.
Yes, my lord, deputy director has granted relaxation. He has given me the permits to sell locally because those granite blocks are defective. My lord, when I make an application under 3G, my lord,
The finding is at para number 38 in the
that
same.
is without any basis, my lord. Without any basis, it is not put on notice to me. If there is, my lord, rule violation of rule 3G, my lord, results in the cancellation of the quarry lease, my lord. My quarry lease is not cancelled as on today. I am operating those quarries. Now, rule 3G is only enabling provision, my lord, where it enables the deputy director to grant me the permission to sell locally. Now, all these granite blocks, my lord, I have transported with the permission of the deputy director of mines and geology. He has granted me the relaxation. The relaxation granted by the deputy director without even getting the report from the deputy director, this order is passed, my lord. And notice doesn't say so. He asked me to appear, I appear. Was suddenly blown from the blue, it says, my lord, you have violated Rule 3G. Rule 3G violation is the only enabling provision. It enables me to apply for the relaxation of, on the ground, it is 100% export oriented unit.
59.
Obligation.
Bill number 19. The Venkatesh Vidalwar.
Petitioner. This is a PAL filed by the High Court Legal Aid Services Committee. What's
Maintenance of park.
maintenance of park?
Various
Okay,
memos of.
prayers are, what's prayers which are made is for the benefit. There is no adversarial prayers which are claimed. The amended petition, my lord, 6th of July 2021. What should my kindly? Page 14, para 17C1. These are the act was of 1985, my lords. Therefore, there was no subsequent examination. Therefore, my lord, initially it was filed for one park. The honorable court directed me to file an amended petition to include state-wise authorities. These are the prayers, my lords, which is welfare of everybody. I don't think respondent would have any.
Various memos have been filed in regard to, various memos have been filed in regard to BBMP, my lord. We have maintained the parks and everything is done, my lord. So, my lord, in regard to the prayer, my lord, the state has to take the.
The local authorities and state, my lord, they have to. Nothing in our.
Implementing.
Let them.
The creation of a citizen web portal and CCTV so that, my lord, it's illegal.
What is that portal?
My lord, the maintenance is with the local bodies under the act. And also, my lord, the state government, they have to submit a report. And my lord, citizen grievance cell they have to create, which is not available in the act because of 1985, my lords, there is no amendments at all. These are the things, my lords, which for betterment of parks, my lord, this is a petition by High Court Legal Aid Services. A letter was sent to Honorable Chief Justice of this Honorable Court. My lords, who directed, my lords, the High Court to file a petition, the Legal Aid Services. That is how it has come. There is no adversarial.
We don't say anything adversely. Then they're implementing or not?
They have to implement, but these are the directions I sought, Your Lordship may.
To the local authorities to implement the parks. If the
I
local
appear for Bangalore Development Authority. I have already filed an affidavit with a compilation saying that how many parks are maintained by the BDA and how many parks have been handed over to the BBMP, my lord. We ensure that the implementation of the provisions of the act.
Your Lordship may to see prayer 17C4. So these are all in the updated version of the maintenance. 17C4, page 18 of an amended petition, which I have requested. Kindly direct respond number 1 to create a centralized web portal to place a list of parks, playfields, open spaces in the entire state, and also web portal have a grievance or a complaint redressal forum. Enable the citizens to point out the local citizens will participate with this process. That is the only reason, my lord, this honorable court directed me to make it as an amended petition to include all statewide authorities. Yeah, this honorable court directed, my lords, to include and direct respond number 1 to appoint deputy commissioner of each districts to be a citizen grievance authority.
We allow the president. Implement the.
Please state.
So for orders on, nothing more is required.
Yes.
Orders on 13th of February.
Good.
13th of February.
Till number 20.
Lord, there are
I appeal for a complaint in this case, Lord.
writ appeal 1348 of 2024 is filed by me. Lord, in this appeal, there are two appellants. First one is the Union of India by the Ministry of Defense. And the second appellant is an organization called the Aeronautical Development Agency. Lord, this is a society under the DRDO, tasked with conducting research in aeronautical sciences and also to develop indigenous aircrafts. One of the first tasks given to the Aeronautical Development Agency was developing a light commercial aircraft called as the Tejas. Lord, the respondent was an employee with the Navy. He was serving the Navy. Between 2008 and 11, he was attached to the ADA. He continued to draw salary from the Navy, but he would discharge some air engineering duties with the ADA. In 2011, we called for applications for the post of Scientist F. It is the scientist cadre post. So we issued an advertisement. The respondent number 1, or rather the respondent, applied for that post. Interview was conducted and he was selected. And he was appointed to that post on 29/4/2011 to the post of Scientist F engineer, which is basically a desk job. The qualifications for that were include MBA, engineering along with MBA. This post did not require any flight testing experience at all. That was basically a desk job of scheduling, monitoring, etc., sitting in the chambers and working. He consciously applied for that post. He was appointed, and then he took VRS from Navy, and he was serving in that capacity. Now, among the other things, the ADA also undertakes testing of aircrafts. Now, there are two types of aircrafts, one which takes off from land and the other which takes off from a ship, a carrier ship, with a very short distance. And we had developed a facility for the shore-based training in Goa. And there, in due course of earlier, under the ADA, there is an organization called the National Flight Testing Council, National Flight Testing Center, which would have a pool of flight test engineers. Now, the job of a flight test engineer is to ensure that the flight is ready. The pilot will come and fly, but the job of the flight test engineer is to ensure that in all possible ways, the flight is ready to take off. Now, this National Flight Testing Center would maintain a pool of about 10 flight test engineers, which are drawn from
the HAL as well as the Indian Air Force. At some point of time, we decided that we should have our own flight test engineers. And with approval, 4 vacancies were created for flight test engineers. And 3 of them were formally appointed. After advertisement, they were appointed. Now, since this officer was already serving with us as a scientist F, and he had already worked with the Navy, we thought we will convert his position from scientist F engineer to a flight test engineer. And that order of conversion, or rather the order of approval of conversion, is available at page number 251. Would your lordship kindly have a look at that order?
It is about some fixation of pay.
I'm sorry, my lord.
About fixation of some pay.
No, it's promotion, my lord. It's from-
Promotion. It is basically,
Promotion.
it's basically about which cadre he was appointed. I'll summarize in.
This can wait.
No, my lord,
Lord, it
on my
requires
request,
some time, my lord. It requires, there are various complicated issues involved.
on my
He has
request,
also filed an appeal.
on my request, my lord, the matter is fixed today because, my lord, I'm retiring by end of this month. That's the reason, my lord.
So we are hearing.
Allah, despite his retirement, I mean, he will be, if he succeeds,
But
he'll be anyway entitled.
No, the difficulty
That
is,
doesn't-
my lords, that, my lords, tomorrow they should not say. Then, my lord, there are a few things. What is happening is, my lords, I'm staying in quarters also. They say you have to vacate. And, my lords, they are, my lords, not, my lords, forwarding the papers for pension also, saying that you have not provided with the no due certificate. And, my lords, every kind of, my lords, all kinds of harassments, my lords, are happening in the institution.
No, my lord, I deny
Like
all of that.
literally,
I deny all of that.
You're free to do it. Lord, the
Which is why I'm
difficulty
doing it,
is
yeah.
this. Lords, Lords, I have to, Lords, according to them, I have to vacate by, Lords, the end of this month.
About quarter.
Quarters, Lords. Lords,
After retirement,
the
he
other
has-
thing is, Lords, the other issue, Lords, the main issue would be that, Lords, if I'm not given, Lord, the, Lords, they have, Lords, divested me of my flight test duties from 2017 onwards, and I'm not paid the allowance. Now, my lords, if they don't implement, my lords, I retire, my lords, without, my lords, affecting any promotion. The difficulty is, my lords, I'll be losing, my lords, the chance of promotion also. And, my lord, the allowances which I'll get, my lords, by, my lords, flying my lords, aircraft. My lord, even the flying hours, my lords, I will lose. My lord, that is, my lord, the issue. Unlike, my lords, other desk job or anything, that's a different thing. Here, I have to, my lords, fly the aircraft. They should affect, my lords, the promotion. That is not done.
He was found unfit by the committee.
No, no,
Under the rules, there is a committee.
For
The committee
everything,
found
I'm
him
the
unfit
lord's
for promotion.
Most qualified person. And
The
lords say.
settled position is that over the selection
I'll show
committee,
my lords
single judge cannot
how
sit.
there is manipulation, my lords, how there is approbation, reprobation at every point of time, insofar as my case is concerned, I'll establish. There's no difficulty.
You are retiring.
Please, my lord.
When you are retiring,
Lords, end of this month.
it is not possible. If you want to go before different bench, you can go. We have no time. We'll fix the hearing after March. Merely because retiring, it is no ground to.
My lord,
Come
my
to the
lord,
hearing.
the latest judgment of the Honorable Supreme Court, my lords, that apprehension I have, that, my lords, if the promotion is not effected too, my lords, probably I may not be entitled, my lords, for the allowances. And, my lords, the pay which I will be getting it. That's a difficulty I'm facing, my lords. In spite of, my lords, being successful, my lords, for the learned single judge. In fact, my lords, in view of the fact that, my lord, the matter was, my lords, considered and said it will be taken up for disposal. My lords, there was an interim arrangement made. And as such, my lords, I am not even promoted also. It was with an understanding that, my lord, matter will be taken up, my lords, the interim arrangement was made.
Therefore, we are giving you the option. If you want to go before different bench, please say.
My lords, according to me, it may not take more than 15 to, my lords, 20 minutes, my lords. The records are clear. My lords, the learned single judge specifically said there are no rules. My lords, there are, my lords, approbation. My lord, one time they say there is no post. Second, my lord, they only conduct, my lords,
I'll need about 40-45 minutes at least, my lord. There are various complicated issues. There are some principles also I have to place before lordship. If the matter has to be disposed of, my lord, I will need about 45 minutes. Any date that your lordship find, my lord. I am ready today or any other date that your lordship find.
Today, my lord,
Please, my lord.
today it will not be possible. We are not holding the court in the second half.
Only sitting
Lords,
is only in the
request-
morning. Sitting is only in the morning.
My lords, I request one for a shorter accommodation, my lords, so that.
We can adjourn to a nearer date without any commitment or guarantee to proceed because of next week it can be. Or we admit and fix the final.
My lord, that's, in fact, my lords, the first matter, my lords, was posted for hearing. My lords, my lord, sought for some modification insofar as the order passed, which is in my favor. That's why I preferred, my lord, the second appeal, which is listed. My lord, the other appeal is insofar as my lord's pay. The third appeal, my lordship, my lord, I'll try to assess the court by filing my lord short synopsis.
Appeal is already admitted, my
No,
lord. Your lordship.
no. It was directed, posted for hearing, not formally admitted.
Appeal is admitted.
No. There was an order.
Please see the order of 21/9/2024.
It only says post for hearing, no formal.
21/9/2024.
It is there. It is admitted.
My lord, the order says, order in the main appeal. The appeal deserves to be finally heard. It is admitted.
Yes, finally heard.
Allah, it is admitted. Next word is, it is admitted.
Request for a shorter accommodation, my lord.
Lord, since it is
I
admitted, it has
should
to
know,
be
my
heard.
lords, where I stand.
So writ appeal 1842 and writ appeal 1848. In that there is a IA for IA 1 of 24 and 1 of 24 for condoning delay of 132 days. So ordering both the IS in respective petitions. Having heard learned counsel for the parties and having perused the reasons supplied for passage of time dating today in the accompanying affidavit. And further, in view of that, the connected writ appeal number 134024 is being considered by the court. Finally, the delay of 132 days in these two appeals which are connected, deserves to be condoned. It is condoned as sufficient cause is made out. Both the interim obligations are allowed. Because all the appeals shall be listed. Full stop. Writ appeal number 1348 of 24 is already admitted to be posted for final hearing. Full stop. In that view, all the appeals shall be posted for final hearing in 5th of March.
Request for a shorter accommodations. Request for shorter accommodation.
We can keep, but we will not be able to take up. That is 100%.
You needed this month, my lords.
When shall we?
20th February, my lord. Twentieth February.
No, not 24th January.
24?
24th January.
24th January. It's Friday. Yes. Next Friday. Very good.
We'll try to take up.
I may permitted to make a mention, notes if it is permissible, notes can be. Please. Correct.
Number 21, Srinivas V.
My lord, I appear for complainant in this case, my lord. Lord, it is the accused who has to comply with it. My lord, several representations have been given to them. So far, they have not, only the accused number one have reacted, and he has given he has always sought for information from the complainant, my lord. But never complied with the documents given by us.
Your lordship,
Accused number two have not at all reacted.
counsel is not in town. I seek for a short adjournment, your lordship.
4th February.
Much obliged.
A date may be fixed, my lord.
4th February.
Much obliged.
So number 22.
It's in this, we have filed our compliance
Amit,
affidavit,
where we
my
are?
lords. That sought for certain documents, my lords. Whatever is available, we have given. The one which is not available, we have not given. That is the affidavit we have filed, my lords. appeal for complainant, my lord. Yeah, I have not received any. All right.
Give
I'll
copy of the compliance and
Adjourn
out
the-
on petitioner, stand out to 11th February. 23 adjourned, now 24.
Number 23, disposed, seal number 24. Satish K.
Waiting for complainant.
Just short accommodation to give reply.
Order of
Well,
learned single judge is 15th March 2023, my lords.
12th February.
25 disposed, seal number 26. 26, Mr. Malsi.
Lords,
Yes, my lord.
26 to
Direction.
29, my lords. My lords, these are all forest land, as I mentioned.
My lord, it's
Lords,
a
some time
granted
is
land.
required by the state, my lords, to file.
Learned
but-
additional government advocate Pramod Nikishan wants time. This will be order, common order in 26, 27, 28, and 29.
Yes.
To take instructions, stand over to 10th of, 18th of February.
Pledge.
Please.
Seal number 30,
Your RSA
30?
is filed,
That's not-
my lords, and it is pending before this honorable court.
Which one?
My lords,
30?
30, my lords.
What is?
RSA on the very same. RSA is filed by the Forest Department, my lords, and it is pending consideration before this honorable court. It is filed in 2016 itself. I'll produce.
So how RA is against this very order?
The land, the said land, my lords, it's a forest land.
So regular second appeal
Please,
in respect of the very order.
very order filed by the state, ma'am. Not very order, my lords, on the said land. This is with respect to entering the Kata, my lords. But the matter is pending before this honorable.
Nobody is there for, yes, who is for the petitioner?
I'm for the petitioner, madam. I'm appearing for the petitioner. But
Some
I'll
order-
go,
Yes,
I will go through that order, my lord.
all right, go through the order. Learned advocate, Mr. So-and-so for the complainant 6 times, stand over to 7th April. Yes. As requested, Poma as requested, since he wants to go through some papers.
seal number 31, Mr. Abhinav Ramanan.
But I am the accused in the first matter, the complaint for the second matter.
Seal number 31, Mr. Abhinav Ramanan.
Nobody is there. So 8th of, 7th of March. Next,
Please now, which day? Which day?
7th March.
Seal number 32. Srimati Vinita PC. 32.
We have filed our compliance affidavit in this.
It was stated by learned additional government that the compliance will be filed. Most of learned advocate for the petition is not present. Stand over to 12th February.
Seal number 33.
To the complainant, my
Kapil
lord.
Dixit.
My lord, we have filed two processes. We have also issued notice through email, my lord. And yet, after that, the accused has not been present and she has not been responding. My lord, it has been 10 months that I have even spoken to my daughter. We have a shared custody that has been granted. There was a memorandum of settlement that was agreed between both the parties, my lord. Annexure, page number 35, my lord.
Where is your opponent?
Not present, my lord. They're not present, my lord.
present.
Not been appearing.
So learned counsel, Mr. So-and-so states, for the petition states that the other side is not present. In that view, stand over to 11th. February. Next.
34, 35, 36 are urgent. Seal number 37. Zamir Pasha.
Respondent number 4 and 5, deputy commissioner and assistant commissioners.
Not solved.
But government advocate can.
Appear for respondent number 6, madam. Appear for
And
respondent number 6.
additional government advocate shall take instructions whether he represents this one 4 and 5 also. Stand over to 18th of March. Yes.
Any shorter date may I request?
Why, there is no urgency. Some welfare association, you are rickshaw drivers?
No,
They are
respondent,
rickshaw.
yes. A open space, my lord, in the center of the town is
There
granted.
is no urgency. 18th, 19th, 27th February.
I'm good.
This is number 38, Manmohan PM.
We appear for Union of India in this matter.
Matter will have to be heard, my lord, subject to your lordship's convenience.
My lord, what is it about?
It relates to, my lord. We had, my lord, there was an amalgamation between two companies.
Long.
Lord,
Long
can I make one request, Lord? The respondent company, Lord, with whom, Lord, this company has amalgamated, they had filed a memo for withdrawal of the appeal. And, Lord, simultaneously, Lords, they have not said, Lord, they have filed this appeal challenging the order single judge. Simultaneously, they issue a circular saying that they'll implement, Lord, the order learned single judge. And that, Lord, is challenged before, Lord, learned single judge, and there's an interim order. In fact, on the last occasion, Lord had not also asked them how you can file an appeal and say that I'm challenging the order. Simultaneously, Lord, implement the order by filing with another.
Whenever you want, 18th of February,
Please.
19th of February.
Please.
Office options will be removed in the connected, in the appeals wherever required before the next.
Please.
Number 39.
39 delay of 36 days.
Appealing for appellant, my lord. We have served the copies.
225 are not served. Yes, 225 are not served. 2, 5 and 7.
7 is served.
We have served the copies, my lord.
Then endorsement says they're not served.
I'll verify in the office, my lord.
Learned advocate wants to verify the spectrum of service to respondent 2, to respondent 5 and respondent 7. Time is granted, stand over to 20th March.
Much obliged.
So number 40.
For the appellant, my lords. Let's, morning I've taken the steps, my lords. I'll just serve the copy by the due course of the day. Morning, I've taken the steps today morning, my lords. I've played the process. I've taken the steps morning, my lords. I'll just
Taken-
serve, I'll serve the copy in the due course of the day, my lords.
You are petitioner.
Please, I'm the appellant.
Learned
my lords.
advocate petitioner wants time to serve copy of the appeal to the other side, stand over to which date?
Lords,
19th
the
of
coming Wednesday, 22nd.
February.
41, 42 are urgent. Number 43. Vijay Kumar K. 43.
Nobody is there, 17th March,
Submission with council submission.
17th March.
44. Office submission, council
For the
submission.
petitioner, my lords, we will delete A1 and A2, my lords, direction of the learned single judge.
44,
Please, my lords.
yes.
I may be permitted to delete A1 and A2, my lords. Direction of the learned single judge is only against A3. Notice may be issued to A3, my lords.
What is your good name? Deepika Joshi.
Soumya Anand, my lord.
Soumya so and so states that she may be permitted to delete respondent 1 and 2
Please, my
from
lords.
the area of the parties in view that the directions contained in the order under contempt is only against respondent 3.
A3, my lords.
Also, permission is granted to delete the said respondents at the cost and consequences of the petition.
My lords, notice to A3, my lords.
Notice to notice to respondent 3
Please, my lords.
returnable on 19th of February.
Please, my lords.
Number 45. Shravan S. Ropre. Office submission with council submission.
40
45.
office of this. Nobody is there. 19th March.
Number 46. 14%.
For the accused, your
Vallabhai?
lordships seek for an adjournment anytime in February.
13% is absent, 44, 46, 14% is absent. Learned party in person, learned petitioner party in person is absent. Learned advocate Ms. So and so prays for time, stand over to 18th of March as requested.
Obliged.
47. Chetan Jadhav.
The complainant. My lords, the office objection is that, my lords, that respondent number 2 and 3, my lords, are also made party to the contempt. My lords, the direction, my lords, was as against the first respondent. My lords, to file a report, either a charge sheet or, my lords, a closure report. My lords, now because, my lords, the first respondent has not done it, the other superior officers, my lords, who were under an obligation, my lords, to see that this order is complied, they also, my lords, have turned a blind eye. In fact, my lords, have been approaching them, requesting them, I've brought the knowledge of this, the order of the learned single judge to their knowledge, but nothing has happened.
What is to be done?
My lords.
What is to be done?
Now, this is a fresh matter, my lords. Notice will have to be ordered. The
So they are not party to the petition. There is no direction against them.
there was no direction, my lords, but they are the superior officers, my lord. They are the superior officers. My lords, I'll restrict my lords, the notice to the
Notice notice shall be issued to this from the three only. Full stop, returnable on 19th February.
published.
Number 48.
My lord, I appear for the appellant in this matter, my lord. The office objection is regarding production of translated copies, my lord. I have written a submission that these documents I'm not relying on. For the reason, my lord, the appellant is the Commissioner of Income Tax TDS. Here, the short point of issue is that
48, in relation to the translated copies, is dispensed with. However, it is clarified that if in course of the hearing, the translation is needed, it will be obligation on part of the petitioner to supply. the
but there is a delay of 23 days, my lord. Notice has to be.
To be notified. The appeal along with the delay applications will be notified on 23rd of January.
Number 49, Mr. Sachin BS. Number 49.
Office objection is that, my lords, Xerox copy of photograph is placed on record. My lords, the respondent has supplied the copy of Xerox copy to me. All those documents is part of it.
Xerox copies of the photographs are supplied in that view. For the time being, the office of in that regard is dispensed. The appeal may be listed on 28th of January.
Great.
Still number 50, Mr. Nityananda Murthy P. Number 50.
None present, 15. None present, full stop, stand over to 20th February.
Still number 51.
My lord, I am for the
Case
petitioner in this case, my lord. Petitioner in this case, my lord. I've challenged the order passed by the respondent number 5 who fell various species of trees and already they fell the trees and belongs to the respondent number 1 to 8, my lord, and 19. And my lord, illegally the order has been passed to cut the trees and to lift the tree, and my lord. So already they fell the trees and sought for the interim relief of not to lift the trees, my lord. Because
My lord, my statement is ready. I'll file it in the
tenure
office.
of the land and all, your lordship is aware that is a, by saying that is a Paradina land, and because it is also challenged under the other writ petition in PAL, my lord. So I request this honorable court to kindly direct note, issue notice to them. It is comes within the tiger reserve and all this, my lord. Eco-sensitive zone, Nagarwala tiger. Including the rosewood tree also they cut, my lord. That is not permissible. That areas comes within the tiger reserve, eco-sensitive zone, Nagarwala tiger zone, my lord.
My lord, my statement is ready. My lord, I'll file it
Notice
in
has
the.
to go, notice in 2-3 days of hearing, the matter has not been reached, my lord. Notice has not been ordered. So
You remove the official.
my lord.
Better type copy.
Pardon. My lord, office objection, my lord, is only, that may be overload, my lord. This is only a GPA which has been given by the landlords for the purpose, because I am not having the
My
access.
statement is ready. I will file it in the office.
Office objection is overruled for the time being.
Notice may be ordered, my lord.
Put up notice. Notice returnable on 4th February, 11 additional government advocate accepts notice.
My lord, one submission, my
Correspondence
lord.
126.
My
My
lord,
lord, there are private respondents also, my lord. Many private respondents.
Then it will
Notice
owners
will
of
have
the,
to go
owners
to
of
all
the,
of them.
take notice, my lord.
take, but then there is nothing in the matter.
My
My
lord,
lord, there
my
are,
lord, one submission request, my lord. Already they felled the trees within the eco-sensitive zone, tiger reserve and let them not lift the, till next data hearing, my lord. My lord,
my lord, 5 to 10
My lord,
are the owners, my lord. They'll have to be heard.
So the parties, if private parties are there.
Yes.
my lord,
And additional government advocates, the Nilofer Akbar accepts notice on behalf of 1 to 6,
Respondents 1 to 4.
1 to 4.
Yes.
why also?
The rest of the respondents shall be served
No, 5 is
No,
Sharana Basappa.
by the
Yeah,
petition.
that is
the-
Deputy
name him
Conservator
as
of
a-
Forest.
No, he is a party in person. I cannot accept.
Okay,
Served by the petitioner before the next day. Hand delivery,
my lord.
summons by hand delivery, service by hand delivery.
And delivery.
Hand delivery, not possible, my lord, I will take. My lord, one submission, they already cut the tree and it is lying. My lord, rosewood trees, all these things, my lord, they cannot, they will not have any without the permission.
Serve by hand delivery and we keep it early.
My lord, till next day, very, my lord, not to lift the.
No, my statement is ready.
4th February.
Obliged.
4th February.
Lordship,
Watch.
Lordship, kind leave your Lordship, sincere apology. Serial number 32, by the time I entered into it was adjourned. In fact, your Lordship, they have filed a compliance report to which I have filed my rejoinder saying that it was a partial compliance. In fact, in the cause list, all the respondents of government, they have taken notice and they have filed the compliance. It is showing process to serial number 32, your Lordship.
So it is kept on 12th of February.
Pardon?
It is kept on 12th February.
Please, grateful. My sincere apology.
Last